ಮಾರದಂತವ್ರಿಗೆ ಜೂಜಾಡೋ ಚಟ ಇತ್ತು, ಇನ್ನು ಇತ್ಯಾದಿ ಇತ್ಯಾದಿ ಚಟಗಳಿತ್ತು, ಕುಡಿತಿದ್ರು, ಮಾಡ್ತಿದ್ರು. ಅವ್ರ ಸ್ವಂತ ತಮ್ಮ ಚಟಗಳನ್ನ ತೀರಿಸ್ಕೊಳ್ಳೋದಕ್ಕೋಸ್ಕರ ಇದನ್ನ ಮಾರಿದ್ರು. ಯಾವುದೇ ರೀತಿಯಾದಂಥದ್ದು ಅವ್ರಿಗೆ ಸ್ವಹಿತಾಸಕ್ತಿ ಬಿಟ್ರೆ ಜಾಯಿಂಟ್ ಫ್ಯಾಮಿಲಿ ಹಿತಾಸಕ್ತಿಗೆ ಆಗುವಂಥದ್ದೇನಿಲ್ಲ ಅಂತ ಸಾಕ್ಷಿ ಕೊಟ್ಟಿಲ್ಲ. ಅಲ್ಲೆಲ್ಲ ಅವ್ನು ಬರ್ದ, ನೀವು ತಗೊಂಡ್ರಿ, ಕೇಳ್ಬೇಕಲ್ಲ, ಅಲ್ಲಿ ಬರ್ದಿರ್ತಾರಲ್ಲ, ಮೋರ್ ಓವರ್ ಯುವರ್ ಸೇಲ್ಡ್ ಇಟ್ ಕಂಟೈನ್ಸ್ ಎ ಕ್ಲಾಸ್. ಈ ಸ್ವತ್ತಿನ ಮೇಲೆ ಮೈನರ್ ಹಕ್ಕುಗಳಾಗಲಿ, ಕೋರ್ಟ್ ಅಟ್ಯಾಚ್ಮೆಂಟ್ಗಳಾಗಲಿ ಇತ್ಯಾದಿ ಇತ್ಯಾದಿ ಯಾವುದು ಇರುವುದಿಲ್ಲ, ಹಾಗೂ ನಿರುಪಾಧಿಕವಾಗಿ ನನಗೆ ಸೇರಿದ ಸ್ವತ್ತಾಗಿರುತ್ತದೆ. ಒಂದು ವೇಳೆ ಈ ಸ್ವತ್ತಿನ ಬಗ್ಗೆ ಅಂತಹದ್ದು ಯಾವುದಾದರೂ ತೊಂದರೆ ತಾಪತ್ರಯ ಕಂಡು ಬಂದಲ್ಲಿ ನಾನು ನನ್ನ ಸ್ವಂತ ಖರ್ಚಿನಿಂದ ಬಗೆಹರಿಸಿ ಕೊಡುತ್ತೇನೆ ಅಂತ ಇಂಡೆಮ್ನಿಟಿ ಕ್ಲಾಸ್ ಇರುತ್ತಲ್ಲ, ಪ್ರೊಸೀಡ್ ಆನ್ ದಟ್. ಇಟ್ಸ್ ಹೈ ಟೈಮ್ ದಟ್ ವಿ ಶುಡ್ ಡೂ ದಟ್. ಇಲ್ಲದೆ ಹೋದ್ರೆ ಎಲ್ಲ ಅಲ್ಲೆಲ್ಲೋ 10/10 ಎಸ್ಟೇಟ್ ಏಜೆನ್ಸಿನಲ್ಲಿ ಬರೆದಿರೋ ಸೇಲ್ಡ್ ಇಟ್ನೆಲ್ಲ ನಾವು ಮಾನ್ಯ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ. ನಾವೆಲ್ಲ ಇಲ್ಲೆಲ್ಲ ಕಷ್ಟಪಟ್ಟು BLLB ಓದಿರೋದು ಯಾತಕ್ಕೆ? TP ಆಕ್ಟ್ ಸೇಲ್ ಅನ್ನೋದನ್ನ ಡಿಫಿನೇಷನ್ ಯಾಕೆ? ಅವ್ನು ಕೂತ್ಕೊಂಡು ಬರ್ದಿದ್ದೆ ಕರೆಕ್ಟ್ ಆದ್ರೆ. ಪ್ಲೀಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ನೋ, ಸೊ ಎ ಚಾನ್ಸ್ ಇಸ್ ಗಿವನ್ ಫಾರ್ ಯು ಟು ವರ್ಕ್ ಔಟ್ ಯುವರ್ ರೆಮಿಡಿ ಇನ್ ದಿ ಫೈನಲ್ ಡಿಕ್ರಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್. ಅದನ್ನ ಫಸ್ಟ್ ಡಿಫೆಂಡೆಂಟ್ ಇಂದ ಎಷ್ಟು ಭಾಗ ಬರುತ್ತೋ ಅದಷ್ಟು ಭಾಗ ಹೋಗುತ್ತೆ. ಆ ಭಾಗಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಾಗ ಈ ಸೇಲ್ಡ್ ಇಡ್ನ ಇವ್ರದನ್ನ ಅದ್ರಲ್ಲಿ ಅಡ್ಜಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಕೊಡಿಸಿ ಅಂತ ಕೇಳಿ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಇನ್ ಇಟ್ಸ್ ಪ್ರಾಪರ್ ಪರ್ಸ್ಪೆಕ್ಟಿವ್ ಅಂಡ್ ದೇರ್ ಇಸ್ ಎ ಮಿಸ್ ರೀಡಿಂಗ್ ಆಫ್ ದಿ ಓರಲ್ ಅಂಡ್ ಡಾಕ್ಯುಮೆಂಟರಿ ಎವಿಡೆನ್ಸ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂಡ್ ದೇರ್ ಫೋರ್ ಸಾಟ್ ಫಾರ್ ರಿವ್ಯೂ. ನೆಕ್ಸ್ಟ್ para. Per contra, Alert Counsel for the respondent Sri Sadashiv Reddy opposes the review petition. Next para. This court perused the material on record meticulously in view of the rival contentions of the parties, including the judgment under review. Next para. It is the specific case of the counsel for review petitioner banked upon the recital found in the said sale deed, which is marked as exhibit P4, that it has been mentioned that the item number 4 of the suit property is the self-acquired property of the first defendant. Next para. However, the learned trial judge has recorded a categorical finding after full-fledged trial that there was no legal necessity for the first defendant to part away the suit item number 4 to the review petitioner by virtue of the sale deed dated 2011-1990, and there was no material on record to show that the first defendant had an independent income to acquire the suit item number 4 of the suit property so as to term it as a self-acquired property of first defendant. The said finding was subjected to scrutiny by this court by exercising the power vested in this court under section 96 set with order 41 of the CPC while reappreciating the factual and legal aspects. ಆಯ್ತಾಯ್ತು, ಅವೆಲ್ಲ ರಿವ್ಯೂನಲ್ಲಿ ಹೇಳೋದಲ್ಲ. ನಮ್ಮ ಹೆಸರೇನು? ಶ್ರೀ ನಟರಾಜ್, ಕ್ಲೈಂಟ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್, ರೆಪ್ರೆಸೆಂಟಿಂಗ್. ತಮ್ಮ ಹೆಸರೇನು? ಷಣ್ಮುಖಪ್ಪ, ರೆಪ್ರೆಸೆಂಟಿಂಗ್ ಷಣ್ಮುಖಪ್ಪ. ಅಂಡ್ ಶ್ರೀ, ತಮ್ಮ ಹೆಸರೇನು? ಶ್ರೀ DV ಸದಾಶಿವ ರೆಡ್ಡಿ, contesting respondent. First heard ಅಂತ ಹಾಕೊಂಡ್ರಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಬರ. The present review petition is filed challenging the validity of the judgment and decree passed in regular first appeal number 319 of 2004 on the file of this court dated 6th December 2019. ಏನಿದು 3ನೇ ವರ್ಷ ಆನಿವರ್ಸರಿನಾ? ಇವತ್ತು ನೆನ್ನೆಗೆ 3 ವರ್ಷ ಆಯ್ತಲ್ಲ, 6 ಡಿಸೆಂಬರ್. ರೈಟ್. ನೆಕ್ಸ್ಟ್ ಬರ. Facts in brief which are utmost necessary for the disposal of the review petition are as under. RFA 319/2004 was directed against the judgment and decree passed in OS number 1419/1993 on the file of Additional Civil Judge Bangalore, City Civil Judge Bangalore, seeking the said suit was filed for seeking of partition of 1/3 share in the plain scheduled property. Plain scheduled properties are as under. Next para. Suit on contest came to be decreed. Suit on contest came to be decreed, and the same was challenged by the yaro tavena review petitioner. Review petitioner. Next para. The appeal was heard on merits and came to be dismissed. First, in paragraph number 26 of the order under review, this court has held as under. First, next para. Being aggrieved by the judgment passed by this court in RFA number 319/2004, the review petitioner approached the Honorable Apex Court in SLP number 12862 of 2020. First, next para. The Honorable Supreme Court declined to entertain the special leave petition, however, reserved the liberty for the review petitioner to file the present review before this court. First, accordingly, the present review is filed by the review petitioner raising following grounds, questioning the validity of the order passed in RFA number 319/2004. First, next para. Lord Counsel for the petitioner, review petitioner Sri Nataraj, reiterating the grounds urged in the review petition, contended that the trial court has not properly appreciated that the sale in favor of the present review petitioner has taken place in the year 2011-1990, and in the sale deed there is a clear recital that the property was self-acquired property of Vietnam defendant, first defendant, and therefore, trial court ought not to have decreed the suit of the plaintiffs granting share in respect of suit item number suit item number 4, and the item number 4 of the suit property should have been separated. Should have been item number 4 of the suit property would not have been available for partition as on the date of suit, and therefore decree is bad. First, he also pointed out that though the same is urged in the appeal, showing the establishing the oral and documentary evidence on record to substantiate the contentions of the review petitioner, the learned judge who passed the final judgment in regular first appeal 319/2004 on 6th day of December 2019 did not consider the same. This court, as referred to supra in paragraph number 26, has clearly held that the review petitioner failed to prove that the property suit item number 4 of the property was the self-acquired property of the first defendant, so as to sell it absolutely in favor of the review petitioner. First, per contra, the finding recorded by the trial judge, and which was confirmed by this court in the aforesaid first appeal, is based on sound and logical reasons. First, having regard to the scope of the review, this court is of the considered opinion that entertaining the review petition further for consideration as to whether the finding recorded by the learned trial judge in RFA number so and so aforesaid RFA is not permissible, and accordingly following order admission declined, review petition dismissed.